Good morning, this is the Kelso Report for Tuesday, December 6th, and I'm your host, Clark Kelso. It's always dangerous to start making inquiries about what goes on in a juror's mind, or what happens in the jury room. But when possible misconduct is drawn to the attention of the court, it has no choice but to conduct some type of inquiry. And that's what the judge did in People v. Allen, a death penalty case decided yesterday with the California Supreme Court. In this case, the judge ultimately committed error by dismissing a juror, ostensibly for making up his mind before beginning deliberations, when the evidence in support of that conclusion was equivocal at best. And the juror had actually voted undecided during preliminary votes in the jury room. Hard to see how he had made his mind up given that. During guilt phase deliberations, two jurors reported their concern that another juror had made up his mind before the case was submitted to the jury. The judge ultimately spoke with all of the jury panel members and then discharged the juror for having prejudged the case. About the only solid evidence of prejudgment was a statement made by the juror on the second day of deliberations, when the juror said to another juror, "When the prosecution rested, she didn't have a case." I'll say it again. When the prosecution rested, she didn't have a case. Well, this statement arguably indicated that the juror had made up his mind even before deliberations began. However, the standard for discharging a juror is not an easy one to meet. Instead, the basis for a juror's discharge must appear on the record as a demonstrable reality, and involves a more comprehensive and less deferential review than simply determining whether any substantial evidence supported the trial court's decision. Although a reviewing court does not reweigh the evidence, it does look to see whether the trial court's conclusion is manifestly supported by the evidence on which the court actually relied. Well, the record in this case did not come anywhere close to meeting this standard. The juror's statement was made after deliberations had begun, so it was readily susceptible to an interpretation that the juror had withheld judgment until deliberations began, but then concluded the prosecution hadn't made its case. It was very significant to the court that the juror continued to participate in deliberations and even voted undecided at one point. So on this record, it was not a demonstrable reality or manifestly clear that the juror had prejudged the case. Given the trial court's error, the Supreme Court unanimously reversed both the guilt and the penalty phase judgments. Second featured case, the California Supreme Court issued another unanimous decision in People v. Sanchez, where the court clarified the proper procedures to be used when a criminal defendant indicates a desire to withdraw a guilty or no contest plea on the ground that current counsel has provided ineffective assistance. In California, this situation usually involves the trial court holding what is known as a Marsden hearing to determine whether there is a need to appoint new counsel. Naturally, the phrase Marsden hearing is named after a case. In this instance, the California Supreme Court's decision in 1970 in People v. Marsden. Well, after reviewing the case authorities, the Supreme Court concluded that a trial court is obligated to conduct a Marsden hearing on whether to discharge counsel for all purposes and appoint new counsel whenever a criminal defendant indicates, after conviction, a desire to withdraw his plea on the ground that his current counsel provided ineffective assistance, at least where there's some clear indication by the defendant that the defendant wants a substitute attorney. The trial court in yesterday's case did not conduct the Marsden hearing. Instead, it appointed a conflict counsel to investigate and determine whether a motion for substitute counsel would be appropriate. Well, that was error. The proper procedure is to convene the Marsden hearing, to give the defendant an opportunity to state any grounds for dissatisfaction with the current appointed attorney. If the defendant makes a showing during a Marsden hearing that his right to counsel has been substantially impaired, then substitute counsel must be appointed as attorney of record for all purposes. And our one-liners for today begin in the area of criminal sentencing. The federal court in United States v. Grant, where the Ninth Circuit extended the Supreme Court's recent decision in Tapia v. United States to sentencing after revocation of supervised release. Now, you may recall the Supreme Court held in Tapia that federal statutes prohibit consideration of rehabilitation during sentencing, not only in deciding whether to imprison someone, but also for how long to imprison. In Tapia, the district court had lengthened the sentence to facilitate appropriate substance abuse rehabilitation. The Supreme Court held that was error. In yesterday's decision, the Ninth Circuit simply extended Tapia to resentencing following revocation of supervised release, concluding that there was no material difference between the initial sentencing in Tapia and the post-revocation sentencing before the panel. According to the statutes, when you're sentencing a defendant in federal court, judges can consider retribution, deterrence, and incapacitation, but not rehabilitation. Another criminal law case in People v. Muhammad, the 4th District affirmed the defendant's conviction of a robbery, rejecting the defendant's arguments that there was insufficient evidence and that the trial court erred in instructing the jury on conspiracy. As for the evidence, there were several eyewitnesses, including one of the victims, who testified that the defendant was the perpetrator, and that testimony was sufficient for the court. On the instructional question, the defendant tried to argue that conspiracy was not a valid theory of liability in California because Section 31 of the Penal Code recognizes only direct perpetrators and aiders and abettors. Well, the argument's flatly contrary to California Supreme Court authority, which holds that one who conspires with others to commit a felony is guilty as a principal under Sections 30 and 31 of the Penal Code. So the 4th District, in yesterday's decision, affirmed the defendant's conviction for robbery. Next, in the area of public works contracts, in Eggers Industries v. Flint Co., the 3rd District held that the company that agreed with the general contractor to a public works project to provide the custom doors for the project is considered by law to be a subcontractor and not a materialman, even though the company ended up contracting with a third company to actually make the custom doors. The fact that the subcontractor contracts with someone else for that person or company to actually perform the portion of the work the subcontractor has agreed with the general contractor to perform does not transform the subcontractor into a materialman. The issue was important because if the subcontractor was actually considered a subcontractor as a matter of law, as the court found, then the general contractor's non-payment would trigger the right to recover under the Public Works Payment Bond. Follow the money. Our next case is in the area of product liability in Lopez v. Nissan North American. The 2nd District held that passenger vehicle odometers are, quote, correct, close quote, as a matter of law, if they register actual mileage within the 4% tolerance set by the National Institute of Standards and Technology, and the manufacturer does not deliberately miscalibrate them to under-register or over-register mileage. Compliance with the NIST standards brings the odometers within a safe harbor provision in Section 12500C of the Business and Professions Code, which has the effect of barring plaintiffs' claims under California's consumer protection statutes. Summary judgment was therefore properly granted in favor of Nissan North America. In the area of wills, in the state of Irving Duke, the 2nd District held that intestacy was the result when the deceased husband's will was unambiguous in providing for disposition of property when the husband predeceased the wife, or when husband and wife die at the same time, but contained no provision for disposition of property when the wife predeceased the husband by several years, which is what actually happened. In light of the unambiguous nature of the will, the court rejected arguments that there should have been a finding of an implied gift, or that extrinsic evidence should have been admissible to establish the decedent's true intent. Next, the area of evidence in Kaiser Foundation Hospitals v. Wilson. The 4th District held that Section 527.8 of the Code of Civil Procedure which permits employers to seek injunctions preventing workplace violence against their employees, allows the trial court to hear any relevant evidence, including evidence that under the evidence code would be inadmissible hearsay. According to the court, the rules regarding inadmissibility of hearsay simply do not apply to a hearing under Section 527.8, because that section expressly provides that the trial court shall receive any testimony that is relevant at a hearing on a petition filed pursuant to that statute. The court affirmed an injunction which had been entered against the defendant, enjoining him from committing further acts of violence or making threats of violence against two employees of the plaintiff. And that's it for today's Kelso Report. Have a great day in the law.